Hello, everyone. Welcome to today's iteration of the live employment law Q&A. My name is Teilen Celentano, and I'm an employment lawyer and associate with Samfiru Tumarkin LLP, and I work out of our Toronto office. So as always, feel free to go ahead and ask your questions in the comments below, and I'll do my best to answer them live. You can ask your questions through Facebook, LinkedIn, Twitter, YouTube, X, wherever you're watching this. You can also go to our website at employmentlawyer.ca, email us at help@employmentlawyer.ca, or give us a call at 1-855-821-5900. There's two stories I'd like to talk about today. The first is the recent announced layoffs from Cisco Systems. So for those of you who haven't heard, Cisco Systems has announced it's cutting another 7% of its workforce, which is equal to about 5,900 employees. And it's the second big round of job cuts that they've announced this year. Now, the purported reason they're doing it is to focus on growth and AI and cybersecurity. But the reason why a company decides to lay off a bunch of employers or restructure is largely irrelevant to what those employees are entitled to when they are being let go. When an employee is let go in Ontario, there are enhanced severance obligations employers must follow under the Employment Standards Act. And what those obligations mean depend on not only how long the employee has been there, but also how many employees are being let off in this round of mass layoffs and how much notice, if any, those employees were given prior to their last day. But in addition to that, in addition to the enhanced minimum entitlements under the Employment Standards Act, employees also may have additional entitlements under the common law. Under the common law, severance can be as much as 26 to 30 months, depending on the circumstances of someone's employment. Our courts look at a number of factors in order to try to ascertain what that right amount of severance is. It could be the most common things our courts look at are age, length of service, and availability of similar employment. But other factors, such as economic climate, can also sometimes impact how much severance someone is entitled to. So, as we always say, I'm sure in every single one of these shows, it's important that whenever someone is laid off, that they don't just take what the employer is giving them as either A, their best offer, or B, their maximum entitlements. Instead, it is imperative that whenever someone is let go, they reach out to us and so that one of our lawyers can take a look at the package and ascertain really what the maximum is, what their ceiling is, making sure they're being compensated fairly. The second story I'd like to talk about before getting into your questions, and we've already got a few today, which is great, is the recent acquisition the recent news that Mars is acquiring Kellanova. So Mars, as I'm sure you know, Mars bars, M&Ms, Snickers, and Kellanova, Pringles, Pop-Tarts. Those two companies are merging, and when that happens, there's always a bunch of new changes. Not only to the company itself, but on a more micro level, what's happening to the employees individually. There can be cuts as there may be some overlapping responsibilities that no longer need to be covered. And there may also be changes to the conditions of employment themselves. So you may be asked to sign a new contract. You may be asked to change your hours of work. You may be asked to change your location of work. And in these situations, the question always becomes, is my employer allowed to do that? Are they allowed to change these conditions of employment when they switch hands? And the answer is it does depend. The famous answer from lawyers is it depends. It depends on if they're trying to change your location of work. Where did you previously work? Where are they trying to move you to? And how long is that commute? In a lot of instances, if those changes are too big, it can be considered what's called a constructive dismissal. A constructive dismissal is defined as a significant unilateral change to the terms of an employee's employment. So the key word, the operative word is significant, whether or not that change is significant. So as an example, if you live 10 minutes down the road from your current place of work, and because of an acquisition, the company is trying to get you to move to a new facility that is 10 minutes the other way from your home, but still just a 10-minute drive, then that's probably not a constructive dismissal. There probably just isn't enough there. But if your commute time is being significantly increased, well, then that may be a constructive dismissal. One of the difficult parts with these types of cases is it is oftentimes a case-by-case analysis, right? And it is very fact-specific. Moreover, what may be a constructive dismissal for one person may not be for another due to other obligations a person has. Someone may have childcare obligations, so they can't work the other way. They have to pick their kid up from school. So again, our courts do look at the case on an individual basis and try to ascertain whether or not that is a constructive dismissal. So similarly, during these changes, you may be asked to sign a new contract. And those contracts can implement a whole list of things that can negatively impact your employment going forward. For example, they could be trying to implement a new termination clause, which if you were to be terminated in the future, your entitlements would be limited to your minimum statutory entitlements under the Employment Standards Act rather than your full common law entitlements. And the difference can be thousands and tens of thousands of dollars. Generally speaking, entitlements under the Employment Standards Act is calculated in weeks versus entitlements under the common law for your full severance entitlement is calculated in months. A company can also introduce a temporary layoff clause. Most people don't know that a company without a specific contractual term doesn't have the inherent right to place someone on temporary layoff for the first time in their employment. And where they do, it can be a constructive dismissal. However, if there is that clause in a contract, and if your company is changing hands and you sign that new contract, well, then you may be beholden to that layoff clause and limiting your entitlements in the event that you're placed on one. So whenever your company changes hands and there are changes being made to your employment, whether it's a new contract is being introduced, whether they're asking you to move locations, whatever it may be, it's a good idea to reach out to us at employmentlawyer.ca. Book a time to speak with one of our legal reps who will be able to walk you through what your rights are, what the change is being made, and whether or not those changes could amount to a constructive dismissal and thereby entitle you to a severance package, which, like I said, can be as much as 24, 26, 30 months. So starting with today's first question, it's from Yusuf on YouTube. He says, hi, I got terminated while on disability. Employer said, based on medical, I can't work anymore to any capacity, but my doctor didn't say that, or even the insurance all denied what the employer said. And then Yusuf had a follow up, and he said the policy of the employer said that beyond 24 months of no medical support, that for reasonably foreseeable future. What does foreseeable future mean? So just to summarize briefly, so Yusuf has been on a medical leave of absence for what appears to be 24 months, and the company has terminated his employment or has ceased the employment relationship. And the company policy is that after 24 months, there's no medical support for a return to work in the foreseeable future, then this is what they do. So what Yusuf's employer has touched on is what's called frustration. So frustration occurs in every area of law. And frustration is when a contract can no longer be performed through the fault of either party. So it's a lot of people think it's similar to force majeure. It is significantly different. But if a contract, for whatever reason, can no longer be performed, then the general presumption is that the contract is canceled. However, in employment law, when someone's contract of employment is frustrated due to a medical or due to a disability, that employee is entitled to their minimum entitlements under the Employment Standards Act, which, as I mentioned, are significantly less than their entitlements under the common law. In order for an employer to win on that argument, in order for them to actually say that the employment is frustrated, they have to do a bunch of things right. First off, they have to make sure they're getting all the correct medical documentation. They can't just say, it's been 24 months, you haven't given us return to work paperwork yet, so your employment's been frustrated. They have to reach out to you. They have to ask for you to provide medical evidence of what your prognosis for recovery looks like, how long till you could potentially return to work, and what that return to work may look like. Now, those are just obviously your physician in that situation would be projecting into the future. So it is not, they don't have to give a hard and fast rule. They don't have to say on exactly X date, my patient will be able to return to work, but they have to say something to the effect of so-and-so is progressing and a return to work is on the horizon. And if that's the case, then the return to work is foreseeable. It's in the future, and therefore your employment has not been frustrated. And when your employer nevertheless tries to trigger frustration, a court would instead rule that you were just dismissed without cause and you're entitled to severance. The second bit here is a company policy saying that you only have 24 months, so 2 years to get back to work or to have a foreseeable return. That's just not what the case law says. There's been a number of cases where people have been off for 2, 3, 4, 5 years even. And when an employer tried to trigger frustration, the court held that wasn't the case and that employee was instead entitled to common law severance. So in your case, Yusuf, I think it's really important that you reach out to us and talk to one of our lawyers so they can get a full grasp on everything that did happen with your case, what the employer asked for, what the medical documents showed, and then what your return to work does look like. That word foreseeable is unfortunately something that is frequently litigated. There's no hard and fast definition. The common everyday understanding of that word foreseeable is probably akin to what the courts rule, but in order for an employer to win on that frustration argument, it has to be a very fact and hyper specific situation. They have to have really crossed all their T's and dotted all their I's. Ellie on YouTube she's asked a couple, so I'm going to try and read them all in sequence here. If I pursue a constructive dismissal and I lose, can they let me go without a severance? My employer is planning to reduce my commission structure. I'm in sales for doing the same job. I've worked at the company for 24 years and they've given me 16 months notice. My colleague, who is in the same role as me, she gets 18 months notice and has only been with the company for 19 years. Do I have the legal rights to demand more, such as asking for 24 months? I'm 46 years old. So Ellie, there's a bunch of things here that we kind of got to get through one by one. So the first and foremost, a substantial change to your commission structure can result in a constructive dismissal. You're absolutely right. Now, what that change to the commission structure is going to determine whether or not it's significant enough to justify a constructive dismissal, right? The bar our courts use more often than not is earnings, right? It is difficult for courts, and they don't like dealing with things they can't see, they can't calculate, they can't touch. So oftentimes our courts will say, okay, how much would you have expected to earn under the old commission structure versus the new commission structure? And if there's a significant decrease there, then yes, that's a constructive dismissal. If it is small, if it is 2, 3, 4, 5% of your income that's being reduced, that may not be enough. It's really once it starts hitting 10, 15, 20% that it's pretty unequivocal that our courts have said that that's a constructive dismissal. But now that second point you've brought up is notice. So employers must give employees notice of such a change or pay in lieu of notice. And one of the other terms for severance is pay in lieu of notice of termination. So in your case, Ellie, what the company has done is they've given you 16 months notice of this change, right? So if you were to pursue a severance package, then the company would get credit for those first 16 months. How much severance you'd be entitled to does depend on your age and length of service, also the availability of similar work and how much you make. So without really speaking to you, it's difficult for me to say exactly how much you'd be entitled to in terms of a severance package. But because they've only given you advance notice of this, you can commence a constructive dismissal claim as of the date the changes take place, so in 16 months from now, but you can't commence a constructive dismissal claim today. And if you did, then again, the company would get credit for those 16 months. So there's a lot of moving pieces here. And then the other bit with the colleague getting 18 months notice versus you only getting 16. That in and of itself isn't an actionable wrong. It isn't something we could leverage in order to enhance a severance package. But If we can find out if there was discriminatory reason for them giving you less notice as compared to your colleague, then we may. So there's a lot of moving pieces here, Ellie. Again, reach out to us at employmentlawyer.ca to speak with one of our lawyers. But I think generally speaking, your employer, because your employer is giving you so much notice, you may be able to pursue a constructive dismissal at the end of those 16 months, but they will get credit for those 16 months that you've been on notice. A second question from YouTube. Silver Star asks, are contractors working for the government considered the same as an employee hired directly by the government? I'm referring to Ontario. Why do they use contractors as well? So I can't tell you why the provincial government does anything. I'm not in politics. I don't work for the government, so I'm not sure why they do it. That being said, contractors who work for a government agency do have rights of an employee. Now, the exact situation in which you were retained matters. Are you retained? Did the government hire you through a staffing agency? Right. So do you work for staffing agency A, who has a contract with the Ontario government, and then you go work on the Ontario government site? Or are you an independent contractor whose contracts directly with the government? And the reason that matters is because if you are an independent contractor directly with the government, then technically speaking, you're not an employee. However, if you are being treated as an employee, if you're being paid as an employee, if you're being controlled as an employee, then even though there may be a contractor agreement in place, you're still considered an employee under the law if and when it gets in front of a judge. In order to determine whether or not that person who's labeled a contractor is truly an employee, our courts look at four big things in order to try to ascertain the true nature of the employment relationship. The biggest thing they look for is control. So what level of control is being exerted on you as an employee? Do you have to show up on a certain day? Is there a dress code? Are you assigned work? Are you told how to do the work? Do you have to ask permission for vacation? Those kinds of things are the things our courts will look at. And the more control an employer exerts, the more likely you are an employee. The second thing our courts look at is a chance of profit or a risk of loss. If you're paid a flat rate of pay, you are paid this much per hour, this much per week, this much per year, there's no chance of profit or risk of loss. Your pay isn't dependent on your efficiency or your effectiveness. It is your rate of pay. Whereas in a contractor relationship, there's a chance that if a contractor does a really good job, they can get paid more. And if they do a really poor job, they get paid less. So that's one of the factors our courts look at. The third is ownership of tools. Do you own the tools required to do the job? Do you have to use your own computer, your own software, that kind of stuff? Or is it a computer that is paid for by the government in this case? Do you have a company cell phone? If you have to drive to various locations on behalf of one of the ministries, is it your vehicle that you're driving or is it the company's vehicle? Who's paying for the gas? Who's paying for the insurance? Those types of things our courts look at. Again, the more the company pays for, the more likely you are an employee. And the last thing is the organizational test. Are you holding yourself out to be a member of a government official, or are you holding yourself out to be a contractor? When you show up somewhere, are you there on behalf of yourself, or are you there on behalf of the government? And our courts look at all these factors and they weigh them and they try to ascertain what the true nature of the employment relationship is. More often than not in my work, people who are paid or is classified as contractors are actually employees and they've been misclassified. Now, the second potential, again, just because I don't know the background, is you work for a staffing agency who then employs you out to the government. In such a situation, both the staffing agency and the government would likely both be considered your employer. What our courts have said is that where two different entities both treat the same employee as their employer, both give them direction, both tell them what to do, both retain certain powers, well, then both employers are responsible for paying severance. Both employers are responsible for ensuring the person is looked after in the event they are let go. And that's called a common and related employer. This happens very frequently with staffing agencies, but also happens very frequently in a number of other jobs. in a number of different industries. So in short, if you're a contractor, whether through the government or through a staffing agency, and you're let go, you likely still have rights. And don't take a statement from your employer or your staffing agency that you have no entitlements as gospel. Instead, reach out to us, go to our website at employmentlawyer.ca, and one of our lawyers will be able to help you out and hopefully advise you what you're entitled to and help you to get that. Angie Wilson on YouTube asks, currently negotiating a severance package with my ex-employer and was offered 7 weeks for 6 years of service. We are asking for 24, but the lawyer advises we settle around 14 weeks based on common law employment. So again, Angie, like I've said before, I don't know the exact specifics of your employment, and what you are entitled to depends on what you're entitled to depends on the circumstances of your employment. Your age and length of service are two of the biggest factors, but other things are also considered. Availability of similar employment is one thing. Your level of pay, whether you were management or not. These are all types of things that need to be weighed in order to ascertain what the right amount is. So I can't advise you either way, whether or not this lawyer has been giving you good advice or not. If you would like a second legal opinion, you can reach out to us at employmentlawyer.ca or give us a call at 1-855-821-5900. But without really sitting down and looking at everything, I won't be able to tell you exactly what you'd be entitled to, whether or not that's a good number. Top programmer on YouTube. How are whistleblowing cases differently? Wrongful dismissal and retaliation case, protected activity as per the Bank Act involving Walmart Canada credit cards, sign-up trickery, and illegal practices. So there's a lot of things going on here, obviously. Generally speaking, employers aren't allowed to reprise against somebody for filing, for blowing the whistle. However, that does happen quite a bit. Especially when it comes to credit card fraud, there are a lot of different things with respect to privacy and with respect to obligations. Unfortunately, this isn't the kind of case where I can really comment on in this venue. But if you were to reach out to us and speak with one of our lawyers directly, they'd be able to really help you out and advise how these cases are being handled. Generally speaking, though, in terms of the severance you're entitled to, that may not change, but there could be additional damages you'd be entitled to for reprisal. And then more pragmatically speaking, the company may want to keep it quiet. So there may be more motivation to settle it out of court versus going to court where there would be a public judgment written and be made available. Arch M on YouTube asks, my niece has been working as a seasonal worker for the last several years. Recently, she was told she wasn't being brought back for the next season. Is she entitled to any severance at all? So it would depend on the nature of the employment agreement, whether or not she signed a formal one, and if not, and also whether how long the breaks were in between her terms of employment. So if this was a situation where she was working for 2 to 3 months every summer, as an example, so it's a summer job, you work June, July, and August, then you're off for 9 months, then there may not be enough continuity to really entitle her to severance. Conversely, if she was signing new employment contracts every year that were 3 months, that were for 3 months at a time, and there was not necessarily an expectation that she would be brought back every year, then she may not be entitled to anything. So I think it's always difficult. And then the last point is notice. She had, again, I don't know how long, how long it is until her next, what would have been her next, season working. But if it is 9 months, then that may be adequate notice based on how long she's worked there. So I think in a case of seasonal employees, it does get extremely difficult, and it does depend on the nature of the business, how long they were there. However, Arch, if your niece was just working for very short periods relative to the amount of time she was off, she may not be entitled to anything. But whenever you're not sure, reaching out to us at employmentlawyer.ca or going to our website at stlawyers.ca, where we have blogs which may be more beneficial to this specific situation. Your follow-up, would she be considered a contractor? Likely not. Contractors are very specific roles. She was likely an employee, but the question is always just whether or not that employee is entitled to severance based on the circumstances of their employment. Kevin on YouTube asks, laid off after being at the company for 11 months. The package includes 7 weeks plus a prorated bonus and group benefits. I'm 50 years old. Can I request 4 months for the transition? So you can request more, Kevin. Again, there's oftentimes no harm in asking. However, there can be. Technically speaking, whenever you make a counter offer, you are rejecting the offer on the table. So there is a world in which you may say, I want 4 months, and they say, you know what, we don't want to give you anything else. We're not even going to give you the 7 weeks we initially offered you. Now, that behavior is exceedingly rare because companies are almost guaranteeing future litigation. However, it is a potential. In cases like yours, Kevin, I do recommend asking for a little more money to see if you can. And I think anywhere from 4 to 6 months is your first ask is a fine starting point. But whenever you're handling it by yourself without, a knowledge of the law, it can get very tricky. This is the type of thing that we deal with on an everyday basis. All of our lawyers, all of our paralegals, all of our legal reps deal with this exact type of issue regularly. And we're quite adept at navigating the waters and making sure our clients get the most money they can. So while you can ask for 4 months, there are certain risks and there are certain pitfalls that you could fall into. So it may be best for you to reach out to us at employmentlawyer.ca and speak with one of our lawyers before responding to the company. My last question is from Stan L on YouTube. I'm currently on a medical leave with employment insurance. I've been employed at the same company for over 15 years. My employer informed me that my group benefits no longer apply due to my sick leave, is terminating employees' group benefits while on medical leave through EI Legal. So it depends on a number of things. It depends on how long you've been on a medical leave. It depends on whether or not there's that reasonable, foreseeable return to work. And it also depends on how much notice you were given and whether or not there was any notice given, right? Or any policies that pertain to this. Generally speaking, if a company just arbitrarily cuts your benefits off while you are on a medical leave and using those benefits, that can be a constructive dismissal. Like always, constructive dismissals are very fact specific, and our courts look at every case on a case-by-case basis. But based on what you told me, it does sound like you may have a claim against your employer for constructive dismissal. And if you are constructively dismissed, it is treated as just a normal without cause termination, entitling you to severance. Having been there for over 15 years and currently being on a medical leave, you may be entitled to a very significant package. It could be as high as 24 months, depending on a number of the other factors I've discussed today. So I think, Stan, in your case, reach out to us, talk to one of our lawyers who'll be able to advise you whether or not in your specific case it is a constructive dismissal, and if so, what you'd be entitled to. That's all my time for today. Thank you, everyone, for joining. Again, my name is Teilen Celentano. I'm an employment lawyer and associate with Samfiru, Tumarkin LLP, and this was the live employment law Q&A. Thank you.